Today, we're diving deep into a fascinating and, frankly, almost forgotten legal document, Charles Wiseman's Treatise on Arrest and False Imprisonment. Why? Because it lays out a history of laws that seriously challenge what most of us think we know about police authority. So let's see what this old text can teach us.
All right, let's paint a picture. You're driving along, minding your own business, and then you see those flashing lights. You pull over. The officer tells you one of your taillights is out. It's a minor thing, right? But could you be put in handcuffs and taken away right then and there for that? I think most of us would say, yeah, probably.
But here's the shocker. According to the legal principles we're about to unpack, which are rooted in centuries of common law, the answer is a firm no. That kind of on-the-spot arrest would have been considered totally unlawful. So, wait a minute. How is that even possible?
To get our heads around this, we have to start with the single most important idea in common law, which is our first section, liberty is the rule. This wasn't just a nice thought. The entire legal system was built on the idea that freedom was the default setting for every single person. And Wiseman's treatise really hammers this home with this powerful line, the law is very jealous of the liberty of the citizen. Now, jealous here means fiercely protective. This wasn't just some fancy legal talk. It was a core principle. It meant that any attempt to interfere with your freedom, like an arrest, had to clear an incredibly high bar. And this isn't some new idea. We're talking about roots that go all the way back to the Magna Carta in 1215. That famous line, that no free man can be seized except by the law of the land, well, that's the very beginning of what we now call due process. It was a direct leash on the power of the government. Okay, so if liberty is the rule, what about the exceptions? That brings us right into our next section, which is all about arresting someone without a warrant. You can imagine, if freedom is the default, then arresting someone without a judge's permission had to be extremely rare.
And according to the source material, there were really only two. First, a felony. You know, the big stuff. Murder, arson. That makes sense, right? It's an immediate danger. But the second one, and this is where things get really interesting for our taillight scenario, was for a breach of the peace that the officer actually witnessed. So what did they mean by breach of the peace? Well, the definition was super specific. It had nothing to do with a minor ticket or a regulatory issue. It meant actual violence or something that was about to explode into violence right then and there. We're talking brawls in the street, riots, things that posed a real, immediate threat to public order. And this comparison right here gets to the absolute core of the treatise's argument. Back then, breach of the peace meant public violence. But today, the source argues that this term gets stretched to cover all sorts of minor, nonviolent things, like a broken taillight. And that, right there, is how the power to arrest just blew wide open. All right, so let's say a lawful arrest did happen. Let's say it was for a real breach of the peace. What was supposed to happen next? Well, that's Section 3, the path to a judge. Because the common law was just as strict about what happened after the arrest as it was about the arrest itself. The whole process was meant to be incredibly straightforward, no messing around. Once someone was arrested, the officer had one and only one job: transport them. And the destination was non-negotiable. They had to be taken immediately to a judge, because it was the judge's job, not the officer's, to decide what happened next. Now, this is where things might sound really different from what we see on TV. According to this treatise, any detour to the police station, for booking, for fingerprints, for mugshot, before seeing a judge was considered an unlawful delay. The officer's duty was to get you to a court, not to a processing center. And this wasn't just a minor slip-up. Oh no, the legal consequence was huge. It's this wild legal idea called trespasser ab initio. It's Latin, and it basically means trespasser from the beginning. If an officer messed up the procedure, say by delaying that trip to the judge, the entire arrest, even if it started out perfectly legal, became illegal from the very start. So if an arrest was illegal from the get-go, what then? What could you, the citizen, actually do about it? Let's jump into Section 4, the crime of unlawful arrest. It turns out the common law gave people a very powerful tool to fight back. That tool was a lawsuit for false imprisonment. And the definition is incredibly broad. It's any unlawful restraint on your freedom, no matter how short. We're talking even for just a few seconds. If it wasn't lawful, it was false imprisonment.
Depriving someone of their liberty was taken just as seriously as stealing their property. But here's what made it such a game changer. The burden of proof was flipped. Normally, if you sue someone, you have to prove everything. But here, all the person arrested had to prove one simple thing. I was detained. That's it. Then the tables turned, and the officer had to prove to the court that the whole thing was legal. So what was at stake financially? Weissman's analysis points to some serious numbers, potentially $1,000 for every single hour of wrongful detention. That put a very real price tag on unlawful arrests, and it created a huge incentive for officers to follow the letter of the law. Okay, this all brings us to our final section, and this is where the old world and the new world really collide. Let's talk about rights versus reality. Just look at this. This is mind-blowing. Under the common law, if an arrest was unlawful, the officer wasn't seen as a cop in that moment. They were seen as just a regular person committing assault. And because of that, you had the right to use necessary force to resist. Now, compare that to today, where most laws say you absolutely cannot resist an arrest, even if a court later says it was illegal. It's a total flip. And there's one more massive change to talk about: accountability. Historically, an officer's good intentions didn't matter. If they made an illegal arrest, they were liable, period. The source contrasts this with a modern doctrine you may have heard of: qualified immunity. This can protect officers from lawsuits, basically shielding them for what might be called reasonable mistakes, a concept that just didn't exist back then. So when you boil it all down, what Weissman's treatise really does is it holds up a mirror to our current system. It shows us a world where liberty was the absolute priority, and the power to arrest was kept on a very tight leash. And it forces us to ask a really fundamental question, one that's as important today as it was hundreds of years ago. In this constant push and pull between public safety and our own personal freedom, have we drawn the line in the right place?